Hi, good day, doctor. My name is Radnan Anbananthin. For my criminal law one, I will be presenting the topic of the overlap between common intention and common object in Malaysian criminal law, a critical analysis of recent cases. Starting off with the introduction, the Malaysian legal system, a blend of common law principles and unique socio-historical influence, provides a compelling setting to examine the intricacies of criminal responsibility. In cases involving group offences, the concept of common intention and common object are particularly significant. These doctrines outlined in Section 34 and also Section 149 of the Malaysian Penal Code respectively establishes the work frame for holding individuals accountable for their participation in collective unlawful acts. Though seemingly interconnected, these concepts represent distinct legal principles, each with its own specific requirements, implications, and subtleties. Section 34, which defines common intention, focuses on the shared mental state of individuals engaged in a criminal act with a common goal. It emphasizes the presence of a shared purpose, whether planned in advance or formed spontaneously to carry out a particular crime. But in contrast, Section 149 addresses common objects dealing with the liability of individuals involved in unlawful assemblies. It centers on the shared aim of the assembly holding participation responsible for actions undertaken in pursuit of that common object. Briefly moving into the purpose of the research, this research aims to shed light on the nuanced and often intricate area of shared criminal liability within Malaysian jurisprudence, specifically focusing on the concept of common intention and common object. While these doctrines may appear similar at first glance, they possess distinct characteristics and implications that are vital to understand how culpability is assigned when multiple individuals participate in unlawful acts. Ultimately, this research aims to underscore the practical significance of understanding the distinction between common intention and common object. It will demonstrate how these concepts play a crucial role in ensuring fair trials, just outcomes, and the proper administration of justice in the Malaysian legal system. By providing a comprehensive analysis of these doctrines, this research will serve as a valuable resource for legal professionals, academic students, and anyone seeking a deeper understanding of these important areas of Malaysian criminal law. Now let's look into what is Section 34 of the Penal Code. Section 34 of the Malaysian Penal Code is a crucial provision that outlines how criminal liability is assigned when multiple individuals engage in an unlawful act. It states, when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for the act in the same manner as if it were done by him alone. Essentially, this section establishes that if a crime is committed by a group of people sharing a common intention to commit that crime, each person in the group is held individually accountable irrespective of their specific role in the entire act. They are treated as if they acted alone in carrying out the entire offense. The most critical element, however, is the existence of a common intention. This refers to a shared mental state among the participants, a mutual understanding, and agreement to commit the crime. This intention can be pre planned, like a conspiracy hatched in advance, or it can arise spontaneously in the heat of the moment. Importantly, the criminal act must be carried out in the furtherance of this common intention. It doesn't have to be the exact originally planned, but it should be a step towards fulfilling their shared goal. Now let's look into the historical development of this section. The original Indian Penal Code that our Malaysian Penal Code mimics did not contain the phrase in furtherance of the common intention of all in section 34. These words were inserted in 1870 in India, and when the Indian Penal Code was introduced to the Strait Settlement in 1872, the section as amended was also adopted. The additional words were apparently intended to make Indian law conform to English law so that a person who was not cognizant of their companion's intention to commit murder would not be held liable for murder. However, as this was already the state of Indian law even before the Indian Penal Code was amended, the addition of the words was only to entrench the case law in statutory form. However, there has been much judicial disagreement, not just locally but in other jurisdictions as well, on whether liability should be based on a shared intention to commit the collateral offense or if something less would suffice. What is Section 141 of the Penal Code and how is it relevant to Section 149? To understand the concept of criminal liability for unlawful assemblies in Malaysia, it's essential to grasp the interplay between section 141 and section 149 of the penal code. These two sections are intricately linked, with section 141 laying as the groundwork for the application of section 149. While section 149 deals with the consequences of participating in an unlawful assembly, it's section 141 that defines the very nature of such an assembly. Without a clear understanding of section 141, applying section 149 becomes problematic and potentially prone to misinterpretations. By precisely defining what constitutes to an unlawful assembly, Section 141 establishes the crucial framework for determining whether 149 comes into play. It sets the threshold that distinguishes a lawful gathering from one that could lead to a criminal liability for its participants. This is vital because it clarifies the scope of Section 149, outlining the specific circumstances under which individuals can be held responsible for the actions of within the assembly. Another important section to be taken note of would be Section 149. Section 149 of the Malaysian Penal Code addresses the complexity of holding individuals accountable for their involvement in unlawful assemblies. This provision introduces a form of vicarious liability wherein every member of an unlawful assembly can be held responsible for offences committed by other members as long as those offences were committed in pursuit of the assembly's common object or were known to be likely consequence of pursuing that object. This raises several important considerations. First, the definition of unlawful assembly itself, as laid out in Section 141 of the Penal Code, is quite broad. It has a potential to encompass a wide range of gathering, leading to concerns about its possible misuse to criminalize legitimate protests or assemblies that may not have been any intention of engaging in violence or criminal activity. This broad definition requires careful interpretation and application by the court to prevent unwarranted infringement of the freedom of assembly, a fundamental right in any democratic society. Looking into some of the cases are very important, are very crucial for us to understand the nature of these sections. Getting into section 34, in the case of Muhammad Rizwan Gun bin Abdullah and another against public prosecutor 2021, two appellants were jointly charged with two others for section 160. The judge was quite unclear on whether the charge proffered against the two appellate was in furtherance of common intention under Section 34 of the Penal Code or jointly charged under Section 35 or other provisions of the law. The learned judge Armadajaya Awang Mahmud JC stated that common intention is the state of mind common to all persons accused of the offence. It is a rule of evidence and does not create a substantive offence. Common intention may be prearranged or arise in the course of the commission of the offense. True preliminary elements are in fact necessary to fulfill the requirements of Section 34. First, there must be an evidence, direct or by inference, of the accused being present at the scene of the crime. And secondly, there must be an evidence to show that there were a prior concert or prearranged plan involving the accused. Moving on to the following section, which would be section 141, the first case to discuss will be the case of public prosecutor against Tanish Anak Lelaki Krishnan and others, 2021. In this case, the learned judge Shanaz binti Sulaiman JC conveyed that section 141 of the Penal Code states that an unlawful assembly is an assembly of five or more persons. Hence, before an assembly is deemed to be unlawful, one of the requirements is that the number of persons involved must be five or more. In order to be termed as unlawful assembly, this assembly must have five person or more, must be proven to have a common object as stated in any one of the paragraph of A, B, C, D, or E of the section 141 of the Penal Code. Last but not the least, another section for us to look into would be section 149 of the Penal Code. The case of public prosecutor against Muhammad Azam bin Saman and another 2024 provides a compelling illustration of the evidentiary challenges involved in prosecuting cases related to unlawful assemblies under Section 149 of the Malaysian Penal Code. In this case, the judge Muhammad Abazafri, Muhammad Abbas H, acquitted an accused due to the prosecution's failures to establish a key element of the offence, the existence of an unlawful assembly with the required number of participants. The prosecution failed to clarify the roles of these two individuals who played in the events leading to the victim's death, nor did they provide sufficient evidence to link them to alleged common object. This omission was particularly significant given that one of these individuals died during the incident, raising questions about the circumstances surrounding the death and their connection to the accused. This case underscores the importance of meticulous evidence gathering and presentation in cases involving unlawful assemblies. The prosecution must demonstrate a clear link between each individual's charge and the alleged common object of the assembly. Failure to establish the participation of the required number of individuals or to provide sufficient evidence of their involvement in the common object can create reasonable doubt and lead to an acquittal. Looking into the similarities and differences between common intention and common objects. Moving into the similarities, shared liability. Both sections establish a form of shared liability where individuals can be held responsible for the actions of others in the group setting. This reflects the principle that those who engage in collective criminal activity should be held accountable for the consequence even if they did not directly commit the specific act. The second similarity would be the attribution of acts. Both sections attribute the act to one individual to others in the group based on a shared understanding or purpose. In Section 34, it is shared intention to commit a crime, while in Section 149, it is the shared object of an unlawful assembly. Another crucial similarity would be the evidentiary challenges. Proving both common intention and common object often lies on the circumstantial evidence and inferences drawn from the conduct of the accused. This can make it challenging to establish these elements beyond a reasonable doubt, particularly when a direct evidence of an agreement or plan is lacking. Next, the key distinctions to be elaborated firstly would be the number of individuals. Section 34 applies to any group of two or more people, while Section 149 requires at least five people to constitute an unlawful assembly. The second difference would be the focus of liability. Section 34 focuses on the shared intention to commit a specific crime, while Section 149 focuses on the shared object of the unlawful assembly, which may encompass a broader range of offences committing in pursuit of that object. The last distinction between both would be the degree of participation. While Section 34 generally requires some level of active participation in the offense, Section 149 can hold individuals liable even if they did not directly participate in the specific offense, as long as it was committed in furtherance of the common object and they were members of the unlawful assembly. Now let's look into where the Section 34 and Section 149 overlaps. While Section 34 and 149 of the Malaysian Penal Code are distinct provisions addressing different aspects of shared criminal liability, there are scenarios where their application can overlap, leading to complex legal considerations. This overlap typically arises when a smaller group within a larger unlawful assembly forms a separate common intention to commit an offense that also furthers the common object of the larger assembly. To illustrate this overlap, consider a hypothetical scenario. A group of seven individuals forms an unlawful assembly with a common object of rioting and causing damages to property. During the riot, three members of this assembly breaks away from the larger group and with a shared intention assault a police officer. In this situation, both Section 39 and Section 34 and Section 149 could potentially apply. Section 34 could be used to prosecute the three individuals who directly assaulted the police officer due to their shared intention to commit the assault. Simultaneously, Section 149 could be used to hold all seven members of the unlawful assembly liable for the assault as it occurred during the riot, which was the common object of the assembly. Among the cases the court has handled in such an overlapping situation, one of the case would be public prosecutor against Muhammad Azam bin Seman and another, the one that I mentioned just now. In this case, which involved three accused charged with murder under Section 302, a red with Section 149. The prosecution alleged that the accused were part of an unlawful assembly that caused the death of the victim. While the primary charge was under Section 149, common object, the possibility of common intention, Section 34, among the accused to commit the murder cannot be entirely ruled out. The accused might have shared an intention to kill the victim, which also became the common object of the unlawful assembly. The High Court focused on proving the existence of an unlawful assembly and the common object. However, the judgment also indirectly touches upon the concept of common intention by analyzing the accused's action and their participation in the unlawful assembly. As a conclusion, this research sought to provide a clear and insightful analysis of shared criminal liability in Malaysian law, with a specific focus on the often confusing concept of common intention and common object. By meticulously examining the relevant statutory provision, namely Section 34, Section 141, and Section 149 of the Malaysian Penal Code, and analysing their application through a careful selection of case laws, this study has endeavoured to offer a comprehensive understanding of these doctrines, their distinctions, and their interplay in the Malaysian legal context. That will be it from me. Thank you very much.